Great Britain formally left the EU on January 31st. Since then, there has been a transition phase until December 31st. Until then, existing EU law will continue to apply in and vis-à-vis the United Kingdom, including the internal EU investment securities associated with the internal market. The European Union and Great Britain are currently negotiating a future partnership, aiming for an orderly exit with an exit agreement, as well as a free trade agreement with corresponding investor protection measures. Although at the moment, after all what happened last week, it looks really dark and we are more likely going towards no-deal Brexit. And since the negotiations have not yet led to a clarification of the legal situation beyond the transition phase, and the corona pandemic has recently led to delays in the exit negotiations, it must be assumed at the current stage that there will be a hard Brexit. And as I said, what last week did makes it even more likely. As a result, Great Britain will receive the legal status of a third country vis-à-vis the European Union from January 1st. Furthermore, since July 1st, it has no longer been possible to extend the transition phase. Due to the legal uncertainties and the lack of alternative regulations, the principle of investment protection in the form of investment protection agreements can play a major role in the future. Such agreements are international treaties concluded between two, and that means bilateral, or several, that means multilateral, countries. There are over 3,000 such investment protection agreements around the world. The Federal Republic of Germany has concluded more than 130 bilateral investment protection agreements since 1959. The Treaty of Lisbon in 2009 transferred responsibility for negotiating and concluding the agreements to the European Union. The EU Commission is thus given the opportunity to conclude investment protection agreements for the European Union and its member states. Accordingly, the agreement of a new investment protection agreement between the EU and the UK is conceivable. The whole purpose of the investment protection agreement is to protect investments from depreciation. And just for your information, in Germany today, once again, we have more than 30 degrees, and you might see this in between, so you will know why I'm sweating. And it's September. But let's go on. In principle, all investors belonging to the contracting state can refer to an agreement, whereby the affiliation is determined by the company's registered office. Typical contents of the regulation concern topics that are particularly relevant for investors, such as the protection of property against expropriation without compensation, the free transfer of capital and income, and the protection of capital investments. Brexit can lead to significant investment losses. This is where investor lawsuits come into play. In practice, the main starting point for the assertion of claims for damages will be the restriction of business opportunities, especially for companies based in Great Britain that lose access to the internal market or, in the case of regulated industries, an essential operating license at European level. The question of whether an investor is entitled to a claim for damages against the state is in practice a legally complex question in each individual case. A normative starting point for such considerations can be found in the fair and equitable treatment standard under investment protection law. This standard, which is laid down in investment protection agreements, stipulates that states must provide for predictable framework conditions in order to ensure a certain predictability of the investment environment. If this is violated, a claim for damages does not appear to be excluded, at least from the outset. Arbitration proceedings are carried out according to established rules, the rules of arbitration. An example of such procedural rules is the Rules of Procedures of the International Center for Settlement of Investment Disputes. The ICSID is an independent international organization based in Washington, whose legal basis is the 1965 Convention on the Settlement of Investment Disputes between states and nationals of other states. Investment protection contracts can also provide for certain dispute resolution mechanisms. The chances of success of these proceedings in favor of investors are mixed. The International Center for Settlement of Investment Disputes, the ICSID, examined all arbitration proceedings carried out in 2015 in accordance with the ICSID conventions, whereby 10 of 38 arbitration proceedings, that means only 26% of the cases, were decided in favor of the investor. As things stand at present, it is unclear what impact the end of the transition period will have on investment protection in Great Britain, as a bilateral investment protection treaty between the EU and the UK does not exist to this day. Furthermore, legal protection for investors is limited. Against this background, companies with investments in the UK should in any case have any risks for their investments checked now in order to be covered for all eventualities. And if you now want to know more about European politics, YouTube has chosen another of my videos right here for you in the end screen, right next to your chance to subscribe to my channel. Also in my next video, click and enjoy. Viel Spaß!